Good morning, everyone, and welcome to PMAR's Realtor Advocacy Committee meeting. On the screen in front of you are the members of the committee, joined by PMAR member and State Representative Mark Meek, attorney at law at Allen Brickley, who spent many years being counsel to First American Title Company. Bryan Greene, SNAR's Director of Fair Housing, will be joining us in a few minutes. PMAR staff members, Michele, who is the Director of Realtor Advocacy, and Mary Jane Mansfield, PMAR's Education and Events Coordinator, are also with us today. You are welcome to stay in gallery view, but speaker view might function more effectively for this meeting. Today, we're going to have a conversation about Oregon, real estate, and the history of racially restrictive covenants. This isn't a presentation as much as it is a hosted conversation. We encourage your participation by typing your questions into the Q&A or chat box. We will not be taking questions or comments live, except by committee members, due to the format of Zoom. However, we are, recording this meeting with hopes of sharing it with your fellow PMAR members. Then you can just, Mark, I understand that you worked on the legislation addressing this issue here in Oregon. Do you want to set the scene for us?
Yes, thank you, Javier, and thank you, members, for inviting me today. Mark Meek, I'm the State Representative from House District 40, which is Oregon City and Gladstone, and I've been a Realtor member for 24 years now. I can't believe that. The gray hair shows that's actually true. And I spent a lot of time working with this committee. It was the GAC at the time, but very happy to be invited back in this capacity. In my first year serving in the legislature in 2017, several of us members, including the folks on the housing committee, brought forth some opportunities to kind of reshape the way in which our public interacts with these title reports when they receive their restrictions and covenants. Many times, and you have probably most likely experienced the same or have the same experiences with your clients reading these restrictions and covenants, come across discriminatory language, for prohibiting folks of color, whether it be specifically Blacks, and or even Latinos, or quote unquote Asians, were restricted from living in certain communities, in certain neighborhoods in all of Oregon, but also more importantly here in the Portland metro area. And over the years, we know fair housing laws, and we've always come across those, and a lot of times they're kind of superscripted saying not enforceable, avoid, but it's still the language is in these covenants and CC&Rs. And it's kind of part of my testimony back in 2017 when we were introducing these this hopefully a request to allow those languages to be stricken, was that many times our families are looking at these covenants and thinking about the beautiful. We spend all this time looking for them for a home and finding a home, negotiating an offer. We start going into the details of these restrictions, and suddenly they don't feel as welcome in these communities because the language really just doesn't include them or discriminates against them. And knowing the history of what this neighborhood was developed by can sometimes bring a cold thought to your your perception of the welcomeness of these communities. And so prior to our bill being passed and brought into law here in statute in Oregon, it was almost impossible. You'd have to have high-powered attorneys go through a whole lot of petitioning, and one simple little hiccup could keep you from having this language removed. Well, part of this bill and this new opportunity is that there were two sides of the story. Should we eliminate the history of the discriminatory practices in Oregon, and maybe we should keep it there and let people know, hey, we've really changed. Or if it was really offensive, we really didn't want our communities to feel unwelcome, or our clients to feel unwelcome in a community, we should be able to easily, through a process, have this language removed from the covenants and from the record. And so we passed the bill. It was House Bill 4134 in 2017. And the new statute is in our laws under ORS 93.272 for all of you data nerds out there. And it's actually easily, you can go to OregonLaws.org and pull up this information. And it makes it a little more easier to apply for and have this language removed without having high-powered attorneys, without having to deal with one objection. I don't want it removed because it's important to that they have an opportunity to come and object, but they cannot keep it from being removed based on just their sole, well, we think it should stay in for the prosperity of our history. And so it's much more easier to have this language removed. And I'm very happy to kind of communicate and interact with our members today. I also have a bill that I'll hopefully mention a little bit later about what I call the love letter ban. If you think about some of the discriminatory practices that we perpetuate in our practices and our businesses, putting a love letter out there with a picture of your family and telling them what church you're going to go to, what school you want to go to, the parks, I'm going to walk, I have a family. I don't have a family, I have dogs. The dogs are not restricted, but painting a picture of who your client is can sometimes, really make it an unfair practice for really the process of our families being able to purchase a home based on the merits of their qualifications and the work they did and the quality of their offer. So I don't want to dominate. I want to give, I'll stand back and wait for further questions and listen to Alan.
Well, I would make one comment, excuse me, at this point. I support this legislation. I support this idea, and I'm sure that the title industry does as a whole. There's a practical problem associated with this, and that is these restrictions oftentimes will include other restrictions, such as, it could be setback lines, it could be, limited to residential uses and those sort of things. So there will always be a reference to the restriction as long as it's still effective. And it seems to me that as a practical matter, there's only two ways that you can literally remove it from the record. One would be to somehow redact those documents, the original document, which is one way to do that. I think the other way that you could do it would be to record a redacted version of the original, which would then be the one that is referred to, and that would contain other language which might still be applicable, but which is not discriminatory. So, the petition idea works, but as a practical matter, you're still going to end up seeing it unless you do, I think, unless you do one of those two things, either replace it with a redacted version or literally go back and redact the original.
Yeah, thank you, Alan, for bringing that up, because this has already passed, and it is the intent is to remove that discriminatory provision out of the language, whether it's redaction and or a recomposition of that deeds CC&R, that it comes back in a new form without that provision, and maybe we'll refer to Section 9 omitted, whatever, but it will no longer be visible and or able to be attained.
Mark, I have the first question, I guess. I learned about this shockingly just a few months ago, and I'm trying to understand. And so there's racially restrictive language in the covenants and the deed documents. what would you say the percentages, here in Oregon, how many of these documents actually have racially restrictive covenants?
I would say a lot of the restrictions or covenants in communities or subdivisions or neighborhoods that were established during the 40s, 50s, and 60s will have that language until 1968 when the Fair Housing Laws went into effect. So homes built in those eras, and actually all the way back to 1870 or whatever, if they had any recorded restrictions. City of Oregon City is one of our oldest cities, and it has some older restrictions, and it does have language in some of their restrictions, omit or not allowing certain races or even families to be living in certain communities. And actually, they based it on religious preferences also. So it's actually very prevalent, but I think it should be more, you will see them more of homes built before 1968, and maybe even really close to that time period.
Yeah, I would mention that the latest ones that I have personally observed that contain these restrictions were in roughly the mid 1950s. I haven't seen any, again, personally, I haven't viewed any CC&Rs later than that did contain these restrictions.
And I know all of you must have some questions, so feel free to unmute yourselves or raise your hand. I want this to be an interactive conversation, so please feel free to chime in.
Hi, I'm Whitney Minnick from the Oregon City area, actually. And my question is actually for Bryan. I've been licensed in Oregon for 3 years, but 8 total in another area. In Oregon, I haven't seen this personally in CC&Rs, but Oregon can't be the only state that's having this, unfortunately. Are you seeing this in other states? How are they addressing it? And are there things that we could adopt here? And then also probably a question for Mark, as someone who hasn't experienced this as an agent, and I'm sure with over 50 people on this call too, there are other agents out there. What is the best way for us to approach this conversation when we do come across it with our clients?
So to answer your first question, Whitney, these are all over the United States, yes. I would say in the last couple of years, and certainly in the last year, we've seen many states and some localities, come up with ideas or plans to try to remove them or put some kind of language in the deed, or disavowing the language, something of that sort. But yeah, I mean, the history of racially restrictive covenants goes back, at least 120 years. And, Supreme Court, with a decision in 1917, I want to say, prohibiting racially discriminatory zoning, more or less opened the door for these covenants, but then they all became invalid in 1948 with the Shelley v. Kramer decision. I'm sure I'll have a chance perhaps to talk a little bit more because I have maybe a somewhat different view on this whole issue. But I will say, coming to NAR from 30 years in government and, being close to people in the Justice Department Civil Rights Division as well, this has typically been sort of a non-starter conversation with the federal government and civil rights lawyers, just because they are null and void from a legal enforcement perspective. Every once in a while, this issue has come up to the federal agencies, and usually they just kind of punt. I think communities are certainly free to take these actions, but I'm very interested in just hearing from all of you just what happens on the ground when people see these. Has anyone ever chosen not to live somewhere because of one. I'm in a house that I assume has a covenant. My house here is from 1900 in Washington, D.C. And, you know, the entire inner city, almost in every city, are homes that have covenants. So at some point, I would think that most minority homeowners, if they looked at their deeds, and certainly those who live in the inner cities, which were all white before blockbusting and blacks were allowed to live in them, you know, they've always been, you know, they've been there for the last 60 something years. So I'm seeing this groundswell of these actions. And this is actually, I think, one of my first opportunities to hear directly from agents as to, you know, what is happening on the ground with consumers, and what do consumers seek in terms of this, and are consumers raising more issues today than they have in the last 50 years about these.
Thank you, Bryan. Yeah, you know, again, I want to keep the conversation open. We're getting a lot of comments on the chat. I don't know if Michele, do you want to address some of those, or do you just want to let them exist where they exist?
Yeah, no, it is. Bryan brought up that this is one of his first opportunities to hear from the Realtor members themselves on this, and we've got members chiming in here that, yes, I have had clients choose not to live in certain neighborhoods because of the restrictions. I've had an experience where a buyer opted not to purchase a home because the covenant said they could not sell to an African American, even though, oops, there's so many comments coming in, even though I let her know it was not enforceable. So yeah, definitely it does come up. It comes up on, you know, our title reports. You see it on there, and then you say, now what do I do? It's on the title report. I've got to go over this with my client. I'm horrified seeing this language in front of me. So, you know, the first thing they do is pick up the phone, they call the title company, and then it goes to Alan.
So I'm getting, so even though they're not enforceable, to go through the process of redacting, you know, as Alan said, that would be a daunting task. Is that what I'm kind of getting from you guys? Is it's possible, but it would be daunting?
I think it would be difficult for county clerks to do it. They're the keepers of the record, so to speak. It does seem to me, though, personally, again, that if there was a mechanism to record a redacted version and the petitioner simply took the original document and either recopied it or literally redacted it themselves, that they could record the document as part of the petition, and it would then become the original record regarding that, and it would not have that information in it. And as a consequence, I don't think any title company would refer to an earlier document, but would simply refer to the current redacted version, which I think might be a way to respond to that sort of practical problem.
Chair, if I may, hey, Alan, this is
Yes.
Evan Swanson here. How you doing, buddy?
Hey.
Good, thank you very much.
So I've read ORS 93272. I've even talked to an attorney. I live in a neighborhood in the Southwest Hills, and we have a restriction in our covenants, which, you know, many of us are interested in, my neighbors are interested in eliminating. I mean, I've talked to an attorney, and the attorney was kind of like, oh, it's not enforceable. You know, I don't need to spend time doing that for you. I think many of us are interested in attacking this. I mean, what would be a step in layperson's terms for how a current homeowner could approach this? And is it something they could do on their own?
Well, Evan, let me answer that via the actual statute. And it's the statute is 93.272. And it's a really simple process. you can actually be the owner of the property. You can actually be somebody looking to purchase. You don't have to live in that community or neighborhood. But there is a really simple process of sending the name or documenting. Well, and I don't want to spend a lot of time just kind of going through the process. Very simple process of mailing the petition, or having a petition to have it removed, setting the reasons why it is in violation of the statute. And if you don't get any feedback or opposition to the removal of it from these owners that you send the message to that are under that condition, that restriction, then you actually go to a simple court process to have it removed. And the final step is in the language was that if a court finds only part of a provision to be in violation, under this section, the court shall enter a judgment removing only that part of the provision that is in violation. And so it's not a really difficult process anymore. It used to be very, very difficult. It could spend tens of thousands of dollars with legal counsel trying to figure out, navigate the system. And so the reason we put this into place is that if you want to take action, it's much easier to do. If you don't and you're okay with it, that's fine. And we're not saying that you have to go out and save the world. But if your clients are passionate enough, or somebody is passionate enough, it's an easier tool in order to have this language removed and just stricken from the record.
Yeah, I might mention that it's probably going to be even easier in the relatively near future, because my understanding is, I was not part of this committee, but my understanding is that there was a group, a committee comprised of title company representatives and other real estate attorneys that actually have drafted forms that could be utilized for this purpose. And they've submitted them to the, let me see what it would be. Well, anyway, to the group of individuals or the institution that publishes forms on the circuit court's websites. And they haven't, I checked probably a week or two ago, and I haven't seen them show up on that website yet, but I anticipate that they will be showing up on that website relatively soon, so that individuals, they can read the statute and they go, well, what does the form look like? What do I have to do? Well, it's going to be easier now. As soon as they post those forms on the website, they can go directly to them, pull them off, fill in the blanks, and take it from there.
Mel, you had a question.
Well, what I was going to say is, it kind of sounds like, maybe a good standard of practice would be, when we're helping our sellers get their house ready for market, that they're pulling title early and they're seeing what they can find and sort of trying to address it, maybe even before they go on the market, before they have a buyer, before there's, that sort of chance that maybe, they could lose a buyer because of it. And also, just making sure we can, like Jennifer said, one at a time, getting them done and stricken.
Bobby.
So is this something that a buyer, after they've already purchased a home, let's say they've already read the title, the CC&Rs, and they discovered this, is this something that they can go in and personally try to get amended once they're already occupied and once they're in the home, or is it something that they have to take care of prior to?
Yeah, at any time, anybody, anytime. And I'll just read it real quick. The petitioner shall contain the name of the person, the mailing address of the person filing the petition, name and mailing addresses of all owners of record of those properties, and then the legal description of the property, and then a clear reference to the provision that is in violation. You send it all to those folks, and you have to wait 10 days to get a response back. So it's a pretty simple process, but I like the fact that maybe there is a more simple form that you don't have to worry about missing anything.
Mark, and what's the fee for this? What does something like this cost?
Well, the cost of just the mailing the letters is one thing. Going to court, and it's not, it is a circuit court, and so whatever the standard fees, a few $100 to file a hearing with a judge. It's not with a jury, so it's just the judge. And so it's not like you have to go to, with, like I mentioned, have to have a high-powered attorneys. It's very similar to a small claims court type of process.
Yeah, that makes sense. I'm just kind of afraid that, we're so concerned about, sellers concerned about selling, buyers concerned about buying, and this becomes sort of a passion project after you've bought the home or before you sell the home, to be proactive about this, right? And it could, if it goes to court, who knows how long that's going to take. So I think it's going to take a little bit more than just,
Yeah, it takes a little bit of time, but it's not going to take years' time. It takes months' time. But you don't want to rest the purchase or not purchasing of a property based on the point whether you can or cannot have it removed or the timing of it. So don't put yourself in that jar and pickle yourself. So.
Mark, can you clarify? I thought that I understood that doing this, and maybe it's just at the county level, that there is no cost associated with recording.
Right, there's no cost with recording. Yeah, the only process, the cost is just going to the court. And you actually have to solve the questions. By the way, hi Mary, good to see you out there. Mary made a Slack. And but there is no once the judgment has been made by the court, the judge, the cost goes to the state, county clerk, whomever, to have it stricken. So it's much more simple. That's why we're saying that it's not a high cost and a high hurdle for our families and yourselves to be able to address these restrictions.
And then before I forget too, I had the opportunity to attend a meeting where Bryan was also attending, and I kind of misquoted him based on my filters and what I understood. But I hope, Bryan, you'll speak to this part. What I was super interested in hearing from you was that aspect of how we affect history. How do we see how far we've come when we start removing language? How do we track that? And you had some interesting things to say about that.
Well, U.S. Senator Tina Smith is contemplating legislation which would call on HUD to inventory and catalog all the covenants in the United States, which is many millions. I mean, you asked someone, Whitney, I think, asked about the extent of the problem. This is the way we live. This is not like a one-off. This was standard, right? And so, so having that data, she believes, will be helpful in understanding, development patterns and existing segregation patterns. There have been a number of local projects like this. Washington, D.C., for example, I'm trying to remember, I think it's called Mapping, I'm forgetting the name right now. Minnesota has one called Mapping Segregation, I think, and D.C. had a project too that literally cataloged every single covenant in D.C. and not only every covenant, but whether the covenant was part of the housing when it was built, or whether the neighbors, the community, came together to create covenants. Apparently, in a lot of our communities where the covenants didn't first exist, if a majority of neighbors wanted a covenant, they inserted covenants. And so a lot of communities, and I would say in Washington, D.C., the great share of communities received covenants that way, where people seeing others moving into the community got together and said, let's put some covenants in here. And so having that information, because our patterns today reflect the covenants of the past, can be helpful in shaping housing policy. And so what's interesting is I think they are aware that there are many efforts at state and local levels to eradicate them. And so I'm not sure how that plays in with their effort to record them before they disappear. But they do believe it can be helpful. And Richard Rothstein, who's the author of the book, The Color of Law, has been very confounded by the effort to eliminate covenants. He doesn't believe they should be removed. I think because he's being overtaken by many communities that have decided on this issue, he is kind of modified his stance to say, okay, if you guys want to remove them, but what are you doing to actually address the segregation that they've caused? And I think that's, you know, and I'm speaking for myself. The National Association of Realtors has not taken a position on covenants, but I'll say as myself that, you know, and I'm the VP for policy now. I spent the first year at NAR doing fair housing exclusively, but you know, I think I've looked at, well, what are the barriers to housing opportunity in the country? And this issue has caught fire, and I hear from, you know, the folks in the chat how many families are affected by it and how it can actually affect a deal. I've not seen it affect deals in systemic ways. I mean, I think maybe knowing that they're there may have affected how communities have been shaped over the years. I don't know that removing them makes those communities more inclusive suddenly. But I'm looking at a lot of the policy issues in terms of what are the issues that we can tackle that will have the greatest impact. And, you know, maybe there needs to be some surveys to sort of look at these issues. This issue, for me, has a lot of emotive impact. I'm not sure to what extent it opens up neighborhoods or communities when we do this. And so while I don't throw a wet blanket on any of these efforts, and I appreciate what everyone has said about how the covenants are affecting consumers, you know, I hope that associations, I sort of take a stance that Richard does. I hope that associations don't do this and then wipe their hands and say, we've handled, you know, the big fair housing problem. I think there are just many bigger that these efforts should be combined with, because, you know, these don't have the force of law, and I've not seen data showing that they're, you know, in any great number keeping people out of communities.
Thank you, Bryan, for that. I want to just see, Michele, can you pull up for Oregon this session, House Bill 2550, which is the bill I was talking about sponsoring. And and I wanted to get Bryan's feedback on it, or all of your feedback on it. I know as an agent, a buyer's agent, I'm trying to give my clients the best opportunity. I want to sell them besides, you know, if we're in a multiple offer situation. But, you know, this love letter, because of First Amendment rights, we cannot restrict the buyer from writing a letter and even sending it to the seller's agent. But this law, this statute would make it, as we all know, we have to provide all written documentation to our clients. And this would allow us as a seller's agent to either redact or not provide that letter. Because in my, you know, and Bryan, our communities are becoming more open, segregated, and more inclusive. So I don't see that, you know, well, some, I'm in Portland metro area. But this practice of allowing this letter to go out with the picture of the family, I think can perpetuate these discriminatory practices. And so I would like to get your feedback on it, because this bill is live right now. OER testified about it, saying there's a few things that they wanted to have addressed, but I'd like to get your feedback on it.
Yeah, NAR has generally advised real estate agents to avoid love letters and to avoid, you know, assisting in the drafting and the communication of them. You know, that's from the buyer side. You know, likewise, I think, you know, agents need to caution their sellers that if they're going to look at these love letters, that they make sure that whatever decisions they make, they can justify, because if it appears that they've made a decision on the basis of, discrimination or, some factor in those love letters, it could be challenged, and, maybe so there'll be a finding against them. And so generally, NAR and, our general counsel's office have just as a best practice has said, just avoid them. There are many folks in our association who have argued that love letters are helpful in certain situations. I know at least one CEO who says that many of the members in her association believe that love letters are helping get their clients into houses that would otherwise go to investors. And she's even argued that it's had a salutary fair housing benefit, and that minority people have been able to get into housing. I haven't heard that from very many. I think generally the perception is, that love letters can be used for discriminatory purposes and to avoid them.
Thank you, Bryan. I'm gonna chime in here because I work with a lot of buyers and I work with a lot of minorities, and I'm gonna put somebody on the spot. I mean, because I don't want to tell my personal story, but Mobby, I mean, I know we work in the same community, and I know I hesitate, and I've been guilty of this, so guilty as charged. I've submitted the letter. Do you fear that by adding a picture of our client's Latino family is going to sway the seller one way or another?
Absolutely. And so I don't encourage.
And we still have to submit it sometimes, right?
Absolutely. I don't encourage a photo, but if they say, would a letter help? I definitely say it's okay to send a letter. But I don't encourage a photo. It's not something, because I do feel like I don't want the seller to be persuaded either way. If it's a touching, obviously the letters are very touching, and they speak about the family and how they've, maybe they're the first in their family to own a home. And so it's very touching, and that's great. But if I don't encourage them to write a letter, because to send a photo, just because I do feel like sometimes it could maybe not.
Yeah, and the photo is just over the top, right? But just the letter, you could tell a lot about a person or about a buyer by the way they write, and by just their names. So it's a slippery slope. So what happens on the ground, Bryan, is with competing offers, multiple offers, if we're encouraged to write a letter, I don't know, guilty, first to admit it. I don't encourage it, but if I'm encouraged by this listing agent, I may do it. Does anybody else have a different point of view?
And that's a very interesting point. You're saying the seller's agent is soliciting the letters.
Sometimes, we're encouraged because, they want that personal touch, right? They want that personal touch to the seller may be old school, and they want to know who they're selling it to.
Yeah, see, I think that's where the seller really gets into trouble.
Right.
Right.
What I've been doing for years, and when I was a managing broker, what I taught agents was to explain the discriminatory aspects of the love letters should they read them. And I turn them over and I write decline to read, and they sign and they date it. Now, have I had sellers who have said, nope, I'm reading them? Yes, I have. And I've had sellers make bad decisions based on reading a love letter. Yes, I have. There's my $25. Sorry. But right. I have to say, and it's not a great practice, but when it's my buyer and they write a letter, I submit it, because my buyer's asking me to submit this letter to the seller. And I even have sellers who say no love letters. And if the buyer writes it, I say, I know you said no love letters. They wrote it. I have to submit it. Do with it what you will.
Yeah.
Well, it's an interesting systemic question too, because even if that is what's happening, I really wonder, and I've not done any polling on this. I wonder whether all buyers feel it benefits them. I know for myself, I don't put my photo on Uber. I don't put my photo on Airbnb. My general view is they see my photo, it creates an opportunity for them to discriminate against me. And so I wonder whether African-American, Latino buyers, Asian buyers feel the same. Like I said, I have heard in some instances people claiming that it's helped them, especially when the competition is an investor. But in a market where you're competing against other potential homeowners, call me cynical, but I just don't see how that love letter helps groups who've traditionally faced discrimination.
And that's my point. But also back to the owner-occupied, non-owner-occupied, that is still a disclosable item that is very specific. So we're going to be owner-occupants of this home, et cetera, is always a good practice to share. Because I had a little bit of feedback or flack from our representatives down in the Roseburg area. But, the point is, so if a family submits a letter, but not a photo, but another family does that is Caucasian and matches the neighborhood, then, that's where you have an unfair advantage of competing with those offers. So it may not be that a family of color, BIPOC, buyer is not submitting, but they may be put at a disadvantage. We have so many implicit biases. I spent 18 months working on a task force here in the Oregon Legislature with real estate industries and people of the communities of color related to racial disparities in home ownership. And the numbers are there. There's a grave difference between our Caucasian homeowners at 65% and our closest of people of color of the American Indian or the Native Americans, indigenous families at about 38% home ownership compared to 68%. That's a big disparity. And so the numbers are out there. I think our families do want to be homeowners, and everything we can do to help them and change some of these policies and practices, I think is going to start moving the needle.
And we don't need to Michele, go ahead.
Oh yeah, it's a great conversation, and I'm glad NAR is taking a look at it. What it shakes down for me is you can find out a whole lot about people just by Googling their name on the internet, right? But really what the crux is, and what I think I hear, Bryan and Mark Meek talking about is, do you as realtors want to put yourselves, your business in the position of being that messenger of whatever? I think that's sort of what we're looking at from the realtor perspective on that conversation. And it's going to be a big conversation, I'm sure. But I did want to go back to the chat, to go back to the other half of the conversation here. Steve Russell, who actually is one of our members who reached out to me about this issue, which helped really put some energy behind it. He wrote here in the chat that as realtors, we're part of many situations where transfer of title can be a good place to fix things. Wells, smoke alarms, CO alarms come to mind. It would be a process. It would seem a process for the removal of discriminatory language could be another one. I'm not saying it's the realtor's responsibility, but it could be a place where attention is focused on it. And if found, a title company could have the authority to redact, as Alan stated, without going to a judge. He says, I'm glad the law was passed, but it needs to be modified, in my opinion.
And Whitney, you had a question.
It was actually more of a comment, and we keep talking about the buyer side, but as listing agents, I also believe we have a responsibility, and we did touch on it a little bit, but when I have a listing, I have basically like a cover letter that goes in the MLS documents, and in it, it says that the love letters will not be accepted as part and they will not be reviewed, and especially now in multiple offer situations, And I talked to the seller about their responsibility for housing and also as mine. And as Michele said, as agents, we have that responsibility to lead that conversation and to uphold that. And we are putting ourselves in liable situations if we're not doing it. And so it's really important as the listing agent, I believe, to lead that conversation and have it in writing, that it won't be accepted as part of it, or won't be presented, I'm sorry. And if the sellers have agreed to that, then I'm not presenting it.
That's a great comment. I mean, Michele, I mean, I would think that should be sort of a recommended best practice by not only NAR, but by PMAR. You know, we have a lot of lead time sometimes when we get the listing contract to where it actually goes on the market. We could actually be also talking about some of these restrictive covenants. And if it's important to the seller, you know, to fix this issue, not only not accept love letters, but to, you know, look into at least to bring visibility into this issue. So I think these are great comments.
I'm going to offer one piece of information and a comment. Let me make my comment first. I do a lot of, and have done in the past, a lot of classes for real estate brokers on various issues. And I have consistently for the last 5 years probably said to listing brokers, do exactly what Whitney has just mentioned. Do not accept buyer letters. Simply don't do it. And so, you know, because it can create liability, it could create, you know, any number of situations. And there's nothing, in my view, nothing positive that can come out of reviewing a buyer letter. The other thing, though, it's a piece of information. A student at Portland State University, whose name is Greta Smith, she worked together with the Bureau of Planning and Sustainability at the city of Portland. And there is available an interactive map that shows where racially restrictive covenants exist in the Portland metro area. So you can go to this map. Let's say you have a new listing. You can go to this map and check it to see whether or not there are these kinds of restrictions existing in the on the property even before you get to CC&Rs. I can
Yeah, that's
send,
great, Alan. If you can share that link, or Michele, if you have it, that would be amazing.
Yeah, I was going to say I can send it to you. I'd read it to you, but it's about a full sentence long, so I'll just send it to you. But from the article that I have, yeah.
That would be great. Thank you so much. Yeah, we've got a lot of activity on the chat box here. One of the comments that I read was, you know, some of these restrictive covenants sometimes, you know, they're not only in the CC&Rs, which is kind of a rider to all the title documents, right? Sometimes they're buried in the deed, and that's, I think, what makes it daunting, right? I mean, you'd have to go one by one.
Javier, I'd like to say that sometimes for even the community, the Latino community, it is pretty daunting. I think that, you know, sometimes they probably may not read that deed. You and I are going to probably read it and go over the CC&Rs and know that it's there, but a lot of the times our clients do not, and they have no clue whatsoever.
Yeah.
My background, I used to do docs, and so I used to review CC&Rs and also the deeds. And so I would see them and I was just, you know, astounded, especially here in Portland, of how they were still there.
Yeah. I'm going to put somebody else on the spot. I know Whitney, you come from DC, right? You're sort of new to the area in Oregon City. You know, and what have you seen as differences between, you know, the DC environment? I mean, that's you're much more aware politically, and then coming to Oregon City, what are the contrasts?
Yeah, it's totally different. I was licensed in Maryland, Virginia, and DC because I was in the DC metro area. And in that time, I didn't come across this in the covenants that we had there. The process is just different too. But I haven't had to have those conversations. And that was why I wanted to know, you know, what is our best practices for having those conversations besides apologizing and knowing how to correct it. You know, what are there key phrases that we should be saying? I mean, it seems like common sense of how we would address the conversation, but I haven't had to have that with a client. And if someone has, you know, it'd be great to hear how you did have that conversation with them. But I mean, the markets are different. We had the love letters there. It was, I think, just starting out. It felt like they were really starting to come about. And our market there was also really competitive, multiple offers. I mean, it was very a very lateral line coming from DC to Portland and the inventory issue. So we saw the love letter issues there a lot. There, I didn't present them either. When I first got in and I didn't know enough, I was doing them as the buyer's agent, full disclosure. But when one of our office managers did talk about it as a fair housing issue, it just immediately was like, absolutely, that makes sense. And someone in the comments made a point, and it's absolutely correct, is our sellers could still go on to Facebook and to Google and Google those people, but that's outside of our control at that point. We've done our job to explain the fair housing issue and why we can't present the letters as part of it, or that it's inappropriate to present it as part of it, and that the merit should be based on the offer itself. And honestly, it seemed to solve it. I haven't had an issue with sellers about it. Everyone has seemed to get it. Are there sellers who may not? Absolutely. You know, and if someone has a conversation, if someone could talk about how we address that, you know, that would be great too.
Yeah, no, for sure. So we're you know, it's 10:51. I just want to check on time. We're going to wrap up at 11. I think for me, you know, the big what do we do now, right? Now with where the issue, where do we go from here? And that's kind of the question that I'd like to pose to all of you. And I'm looking at our association as well, because we look at you for leadership and direction. Should there be best standards of practice, you know, locally that says, hey, you know, that this is going to be in the private remarks and all, I mean, this is a crazy idea, right? But is this something that goes in the private remarks and it's totally discouraged? I know that I can't hide my buyers' names when they're named Juan Perez. ¿Verdad, Mavi? Si es que se llaman Juan Perez, where, you know, that's it. Where do we go from here? So anybody can chime in.
Well, I'm just curious because, you know, I'm obviously not a part of the process of making offers, but I'm usually the one delivering a pre-approval letter. And I've often thought it's interesting that we add, you know, that we do have names if we're in a situation where we're trying to remove implicit bias from a decision, a significant decision. I've always thought it's interesting that love letters exist, that names exist, because clearly there are clients we work with who have names that are from different ethnicities, and it's obvious. Is that a discussion that we should be having? I'm not necessarily sure it is or it isn't, but I think it's an interesting question to pose.
And I would tell you, yes, Evan. And before we get kicked off here, I just want to offer you guys. I represent, you know, the Oregon City Clackamas House District 40, but also represent our industry in many ways. And I appreciate your work, and I want to let you know the invitation is always there. I reached out to Michele earlier, late last year or middle of the year, and any ideas, any concerns at the state level, policy wise, happy to talk to you, discuss, come to a meeting, whatever it is, because I think I can be valuable to our industry at this time. So I'm happy to serve.
Thank you, Mark.
I know I'm seeing a few comments in the chat too, talking about best practices, about forms. You know, I know some companies are, you know, putting together their own documentation on this. And I do know that we've got members from OREF, the Forms Committee, attending too. So while you are seeing your Realtor Advocacy Committee and our guests on the screen in front of you, there's a lot of folks involved and interested in this issue who are listening in today that I'm sure are going to be continuing those conversations as well in their committees. So I just want to let you know that there's a lot of people attending today, paying attention to this conversation. Thanks again for having it.
Yeah, thank you, Michele. I see a lot of comments. How many people do we know how many people are actively on the group?
MJ may have that.
Okay.
30 right now.
30.
It says, I saw 45 participants.
30, not counting everyone that's on the panel.
Great.
Well, I think coming out of, last year was the most interesting year of everybody's lives, not just because of the pandemic, but everything going on politically. I think that this is a good way to start our committee with this conversation, and I'm hoping to continue to bring conversations that bring value to all of our members. It's 10:55 right now, so I want to thank our panelists. Mark, thank you for attending. Thank you, Alan and Bryan. We hope to have you back sometime soon. Thank you to our committee members. Michele, thank you for setting this up. MJ, I look forward to meeting with you guys for the rest of the year and having vigorous conversations. Michele.
Yeah, as we wrap up, just a reminder to all attendees that we are able to offer continuing education for attending today, which is just a great bonus. So I know Mary Jane sent that information out, so be sure to fill that document out so that you can get it. But beyond the CE bump on this, really participating in this conversation, staying in contact with me, letting Representative Meek know your thoughts, using NAR as a resource. I don't know how much time you spend over there, but it is vast at NAR, and Bryan's a great resource, his staff as well. As always, when you see it come up in your transaction, you have your team, your escrow officers there to help guide you and inform you and let you know what some options are as well. So I think at this point, just keeping the conversation alive is what we can do. Share information, ask questions.
Thank you, Michele. Should we share with the group that we're starting a little Facebook group to keep the conversation alive somewhere? I know that, we come to these meetings, we go back to do our daily jobs, and sometimes we forget about these things. I would like some of this information to actually live somewhere. And as much as I hate being on Facebook all the time, I think that we need some kind of a hub. So we can keep the conversation going, comments and just more traction.
Absolutely. Yeah. So to that, this is your Realtor Advocacy Committee, and all of our members are welcome to attend any of our meetings. We meet the even months of the year. So our next meeting will be in April at the same time. We start at 9:30 to 11, third Wednesday of the month. We do have applications if anyone wants to join the committee. We really are trying to work at the most diversity so that we can create best policy and conversations. We have better luck having those conversations if everyone's at the table having them and sharing their input. So, and with that, yes, Javier, you're right. We are starting a PMAR Realtor Advocacy Facebook group just for our members and our committee members. It'll be a private Facebook group, so members of the public won't be there, but that's where we can share and be nimble and keep folks informed as issues come before us that we're talking about. This webinar has been recorded as well, so we'll be able to get that out to members who weren't able to be here today, so they too can be informed. Keep talking, it's great.
Does anybody have any final comments or questions? We're about to wrap up in about a minute.
I just want to say, yeah, thank you. I'm very thankful for your work and your dedication to this committee and to our profession and our industry. So keep it up, and look forward to working with you all and listening to ideas and sharing our perspectives.
Thanks so much, Mark.
It's been a great discussion. Thank you for having me.
Yes, and thank you for the invitation.
Thank you, guys. Well, that wraps it up for today. So thanks again, and we'll see you guys in the next meeting. Okay.
Thank
Be
you.
safe out there.